What can some of the pleadings from Dan Markel and Wendi Adelson's divorce file tell us about potential motive in Charlie Adelson's trial? As you're probably aware, Charlie's attorneys tried to get the divorce filings excluded in their motion in limine. They argued that the divorce pleadings were hearsay, and the likely exception to the hearsay rule that the state would argue motive is not applicable because the state cannot show that Charlie had knowledge of each and every filing in that case, as well as the statements therein. So therefore, no motive can be attributable to Charlie. However, the court specifically questioned defense counsel about motive. And indeed, what the judge said was, is there anything to say that motive cannot have multiple tiers? Meaning that Wendi Adelson's desire to relocate the children to South Florida can be attributable to Charlie's motive of doing something to help his sister accomplish that goal. So the state understandably agreed and argued that the evidence will show that Charlie Adelson and the group, the Adelsons, were aware of the relocation and divorce issues between Danny and Wendy. And that goes to motive for the entire crime. In other words, the motive comes from what's in those divorce pleadings. So the court denied the defense's motions and held that the filings that demonstrate there is either motive of Charlie Adelson or motive of a multi-tiered motive of the Adelsons generally, those can be used in evidence in Charlie's trial. So the filings that I'm going to show in today's video are all part of the public record. And specifically, I got them from Katie Magbanoa's record on appeal. So I kind of see this as two prongs. We've got a motive to get her free from custody problems that she was having with Danny. So things like issues she was having regarding their upbringing, including religion, their education, issues she was having with Danny on access to the children and communication, those type of issues, as well as, of course, freedom to leave Tallahassee and move to South Florida. So let's go ahead and get into the pleadings. So first here, I'm showing Wendy's January 14th, 2013 amended petition for dissolution of marriage, which includes her motion to relocate. So first, she filed a motion to temporarily relocate with the kids pending final hearing on relocation. So she wanted out of Dodge immediately. So she requested an expedited hearing, and she requests that she be allowed a temporary relocation with her minor children to Coral Springs because she's been offered a job in Coral Springs with substantially greater income beginning May 1. Again, this is in January. The wife must inform the employers of her ability to relocate and accept this position on very short notice. So, couple thoughts here. I think we'll see in some future documents that this idea that she had to let them know right away, I think there's some question about that. But in general, why is she asking for a motion to temporarily relocate in January when she's still got a contract with FSU? She can't just leave her teaching responsibilities and leave town so she's ready to begin work on May 1. But as far as the motion itself goes, again, focusing on motive, we're going to go here to the actual relocation section of the motion. She argues that she should be entitled to relocate as soon as possible because she's been offered a job beginning May 1st. It's going to pay her substantially more in salary. It's going to increase their access to close family and provide more stability and consistency. And specifically, wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents as they visited every 3 to 4 weeks since the birth of the children. Here she's arguing that the quality of life for both both the wife and the children will improve greatly because the wife will have a better, more consistent job, the help of extended family, and the children will have increased access to extended family as well. Pleading 2. This one is really more relevant because this is the basis for Dan's motion on February 14th, 2014, where he alleges that Wendy basically submitted this document as part of the divorce, and he alleges that there were false and misleading statements. Now, what specifically Dan alleges she failed to include in this affidavit was, one, he argues that she failed to omit a Tia Kref retirement account in the amount of about $145,000. So he says that should have been here. He also alleges that she omitted another Charles Schwab account worth more than $50,000 at the time of separation. So for her, Charles Schwab, we just have $4,000. He said also she understated her salary by several $1,000s, and also he took issue with the fact that any of these assets that are wife's, she valued them at 0. So those are the bases. So now let's move on to pleading 3. So the third pleading that I think shows motive, when Dan filed his answer to Wendy's amended petition, he, in this answer, asks for sole parental responsibility on issues related to education, religion, and medical upbringing. Again, going to this idea of custody arrangement. What does that look like? On the relocation, of course, he objects to the relocation of the minor children because what he accuses of here is that once examined in context, the sole stated reason Wendy seeks to relocate with the party's minor children is so she can be closer to her parents. So here in the footnote, he says, in a January 2013 electronic communication to husband, Wendy claimed that she thought relocation was in the best interests of our kids to be closer to family, more access to a Jewish community, and a happier mom. I think the third one was really important to Wendy. In my opinion, she doesn't mention the economic rationale at all, which lies at the heart of her filed petition. And her written petition doesn't mention the Jewish community at all because the facts are the wife has done nothing to facilitate the children's connection to the Jewish community since the separation. She not only introduced them to a non-kosher diet since the separation, but on her weekends, she refuses to allow husband to continue their pre-separation practice of bringing the children every week to synagogue for services and Sunday school. Notwithstanding that husband has offered wife time-sharing offsets in exchange for allowing that to happen. Accordingly, the only reasons for the relocation are happier mom and more access to wife's parents. And he goes on in the petition and in his answer to basically, again, argue how allowing Wendy to relocate with the children will also disadvantage him and his relationship with his children. Like he says here, under the wife's proposed relocation plan, he'd have to commute 480 miles for time sharing. He'd be unable to go meet them for breakfast, special events, or emergencies. I thought this was really chilling. This would reduce the husband's parenting opportunities and remove the husband from their daily lives. From the husband's perspective, nothing could be worse. That's super sad. Now, the fourth document I'm going to just show quickly because I'm showing it more to show the effect on the next document. On May 2nd, Dan filed a memorandum of law in support of the answer we just briefly went over. But he also gives a whole overview of the case law, pretty much, I think, almost all the cases that existed in Florida on relocation, and basically distinguishes the one that allowed relocation and shows how the ones that didn't basically are more analogous to this situation. So that's basically what this is. But what's more interesting is what this May 2nd memorandum, how that affected our favorite grandmother. Now let's go to the May 3rd email from Donna to Wendy. The subject is info regarding his, quote, memorandum of law email. Dear Wendy, okay, just saw this email this morning. Obviously, his 23-page rant was insufficient, so he's trying to push the court to deny hearing your petition. Again, I'm not a lawyer. I don't know if to prevent any action your attorney must respond or not. Only you and she know that. However, Jibbers has made his divorce a full-time job to attempt to get what he's always gotten, his way. His job allows for lots of time for him to put into this project, and you know as well as I do that all the research he's done on different case law to prove his point is his research, not his attorney's. No matter who did it, he's quoting 13 cases to show why the court should basically throw out your petition. Is Kristen answering this? Does it require an answer to make sure that this is not seen by the court as ignoring his rights? I don't know. You need to find out. So I'd say Donna was quite involved with her daughter's divorce. Here we go, guys. Can you say motive? The most important part of your divorce is relocation. I sincerely hope your attorney understands that this is your non-negotiable. Lots of things are negotiable. That's the one thing that you cannot let her think, okay, well, if it doesn't happen, it doesn't happen. She needs to hear from you how serious you are about this and how it will benefit the children with a close-knit family support system, as well as your significantly better paying job with hours much more flexible than your current job, so that you can spend significantly more time with the children, which requires teaching hours, office hours, court appearances, meetings with med school people, and multiple trips away from home. Those trips, and then she goes on to complain about, Dan's travel and stuff. So again, showing relocation, motive, and how involved Donna, at least in this email, is with this issue, and that, quote, it's non-negotiable. And she even says, so without your parents as backup, parents, one of you would have to stay at home with the children. Your attorney needs to understand that your mother worked full-time in the family's dental practice until September, presumably referring to the date that Wendy left Dan, when she felt she was needed by you for the well-being of the children, to get them through a transitional time with people who love them and see them frequently and with whom they share great affection. Your father has made numerous trips by plane for weekends and changing the patient's schedules around so that he can continue to spend significant time with the children. Both the disappearance of your mother from the position of office manager and the disappearance of your father from the practice for a significant amount of time has caused a decrease in the practice income, money, 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 and the loss of some patients who feel that it's either not being run the same way as it was as when my mother was there full time, or that my father is unable to see patients with problems and has referred them to other offices during his absences. Additionally, this loss of income affects my family because my older brother, also a dentist, purchased the practice from my father in mid-July 2012. He has a monthly payment to make to my father based on the sale of the practice. It isn't fair to him to have decreasing monthly income statements from the practice due to my parents spending so much time here in Tallahassee. My brother is unmarried and is a wonderful uncle to Benjamin and Lincoln. If I'm able to relocate to South Florida, they will have incredibly warm and loving family as an integral part of their lives, not an occasional 2-day weekend trip. Yeah, I'd say that shows some motive. Just my opinion. What do you guys think? Then I'm not going to read all of it. I'm actually going to link Judy's YouTube channel below. Judy, the YouTube lawyer, has read some of these emails in a fantastic voice that you just have to hear if you haven't heard it. So I'll try to link that below. But basically what she does in the email is basically giving Wendy, instructions on how Donna feels Wendy needs to, communicate with her lawyer on this whole, strategy on getting the relocation granted. And so she goes into all of this stuff. This is interesting. It is not feasible to continue to live even in the home you are currently renting. You have borrowed a considerable amount of money from your parents and must repay it for furniture, legal fees, moving expenses, etc. My parents have paid all grocery bills up to this point. Is she paying for anything for these kids? Sorry, my parents have paid all grocery bills up to this point, for which I will also have to reimburse them. I do not want to dip into the money from our marital account, so that as that will have to go towards supporting my children and for their future. Wow. And she says, number two, the other reason why this relocation should happen and it's in the best interest of the children is that the ability for our children to spend quality time with my parents and my mother, a retired elementary school teacher, would be a huge bonus to our children's academic and social progress. In my parents' home, each child currently has and would continue to have their own rooms with appropriate beds, furniture, books, and toys. This next part here was kind of disturbing to me. Here, Mr. Markel has become a religious zealot over the last few years since the birth of our first son, taking him to synagogue with him as an infant so that he can absorb the music and the prayers. He has done the same with our second son. This is also to show the congregation what an attentive father he is. The fact remains that the children are watched by teenage children of other congregants in a sort of playroom while the services are going on. Mr. Markel picks one of them up to come back at a certain parts of the service to hear particular hymns and then returns them to the care babysitters. This is done rather than allowing them to remain home with me. Wow. Wow, wow. When I protested, he insisted. So Wendy protested her children going to Jewish services? Wow. He always gets his way. There are no Hebrew day schools in Tallahassee. Mr. Markel seems intent upon religious training, but feels that only he could provide the best religious training for our children. He is indoctrinating them, not teaching them. If he truly cared about a religious school for them, then clearly one of the 37 Hebrew day schools in Dade, Broward, and Palm Beach County would be a better choice for our boys. My home in Broward County is close to many of these schools and midway between Dade and Palm Beach schools. Another bribe to get him to allow relocation should be the offer of plane tickets, since he does have family that would allow him to use their homes to stay in. But obviously that's a last-ditch effort if all else fails. She goes on to say, ask Wendy if she needs information on grocery bills that apparently they're paying for. And then she says, I'm too angry to write anymore. I'm going to shower, wash my hair, and get ready for you and the boys to come home. Now, it's interesting. So it looks like Wendy must have gone home that weekend. And the reason I say that is because that following Monday and Tuesday, Dan filed motions to enforce an apparent agreement between Wendy and himself on electronic communications. And he specifically referenced Skype. And he had alleged that Wendy had apparently stopped facilitating those Skype calls because she said they were, quote, disruptive and not in the best interest of the boys. Now, after this, Wendy did wind up filing a memorandum of law in support of her motion to relocate. So she must have taken Donna's advice on legal strategy to heart. Right after this, on June 14, Dan filed this reply in support of his objection to the motion to relocate. And basically, he pointed out the weaknesses in Wendy's motion, including the couple cases she cited. One of the sad things is this last statement here. Indeed, if costs are not awarded, then wife and her affluent parents, who are bankrolling wife's litigation so that they can enjoy closer access to the grandchildren, will persist in vexatious and groundless litigation. Yep. And thereby prevent the parents, meaning Wendy and Dan, from reaching a space where they can cooperate, collaborate, and communicate effectively and warmly in the project of raising their wonderful children. And gosh, guys, that's one of the saddest things about this case, isn't it? So the next pleading, again, to show motive, is the actual denial. The court denied Wendy's motion to relocate with prejudice, which means she can't bring it again. I thought it was interesting that the court actually had to lay out a schedule of when they would have custody, and also the fact that they had to include this requirement that the parties make a good faith effort for Skype every 4 days between 6 and 8 p.m. for the parent that doesn't currently have custody of the kids. And the reason for that was the court did deny those motions I was telling you about where Dan was trying to enforce an agreement to Skype. The reason the court denied that was because they didn't have anything on record that showed that an actual agreement had been made. So they remedied that, though. They did, in a way, practically speaking, move in favor of Dan by putting that in this order here. So after this order, what we got was some doozy emails from our favorite grandmother, and I'm going to go ahead and go to those right now. So here are the Donna emails. I mean, honestly, both of these emails, pretty much in their entirety, in my opinion, can be used to show motive. She tells her it's time for action. It's time to take control of your life and not let Jibbers think he's just won anything by having you remain in Tallahassee 8 hours away from the only family you have and lose out on what will be a job that will afford you and your children advantages that they will never be otherwise able to enjoy. So Donna tells Wendy she's got 5 weeks before the court date. The court date they're talking about here is the final hearing date for their divorce. She's like, I know you have a job to do and I know you're busy, but this is for the rest of your life. And motive, consequently, Dad's, mine, and yes, even Charlie's will be affected by how well you can perform and act before July 31st. You can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet. You have a very strong family behind you. Just remember that. Dad and I have done everything we could to try to help you the last 10 months. Now it's time to help yourself. We've even got a plan of action here. We've got plan of action 1. She's supposed to take photos of the boys dressed nicely in front of a front door or the sign of a Tallahassee church. Then change your Facebook status photo to this one so everyone will see this. Perhaps a line under the photo with "New beginnings in Tallahassee" might be nice. Where have we seen that before, where someone changes a picture on Facebook and it kind of sends a message, right? So everyone will see it. Haven't we seen that somewhere before? Apparently she wants the church, the religion to be Catholic. She talks about hiring a private tutor, a Catholic church member who can come teach the young men about Jesus. They're going to be baptized in the Catholic Church. Donna's looked all into summer camp programs and, quote, "We will pay for it." We want him ticked off so he realizes that he could lose control over his kids. We plan to make a financial offer to him to allow this relocation. You need to work this plan and we'll help you through it so that it may affect how much we'll offer him. Maybe he'd be willing to let you relocate if he knew his children would attend a private Hebrew academy like Donna Klein and Boca. Or perhaps he'd like them to invite him to a Christmas party at their other Sunday school. In my opinion, this is just despicable. So basically, she says there's a little over 3 weeks to the mediation. They had one last mediation before the ultimate divorce trial date. And so she's like, let's get this going now. And basically kind of guilting her here, saying, I know that you wouldn't want to think you hadn't done everything. But and I also thought this was interesting. Gary told us that he is not going to hire anyone until after your court hearing and after we try to make a financial offer to Jibbers. Now, Gary's the individual that gave Wendy the job offer for the Boca Raton, the firm in Boca Raton, the personal injury firm in Boca Raton. Gary, is my understanding, was also deposed last week by the state. But what's interesting is, at least, according to Donna here, Gary is going to leave this job open, which kind of flies in the face of why they needed an emergency petition to move anyway. Because didn't Wendy say in her pleadings that she had to let them know, she had to have a decision on the relocation as soon as possible because she had to let this new firm know before her start date on May 1st whether she was able to accept the offer or not. Interesting. Here's some more on motive. We don't want Danny to continue his religious influence over these children any more than what he's already done. If he keeps this up, they won't want to eat in your non-kosher home. And if they see you don't want to attend their shul functions, you'll be the outsider. As they get older and more involved under Gibber's religious influence, they will be able to request which parent they want to live with. Don't allow Gibbers to have this power and control over them. Then in reality, he's going to have the same control over you. Dad and I have changed our lives this year to support and assist you and the boys in every possible way. Charlie has accepted the loss in the office business income for us to do this because he loves you and wants only the best possible future for you. Sounds like a multi-tiered layer motive, doesn't it? It's time for you to show us that you can put on the performance of your life in the next few weeks. Please call us after you read this. We're waiting to talk to you. If you have any other ideas to make a last chance relocation happen, please let us know. Mom and Dad. Interesting. Okay, so then on the second email that Donna wrote, it was ultimately forwarded to Wendy on Thursday, the 27th. And basically she starts out, they must have had some conversation that we don't have here about this, plot to make the children Christian or make it look like the children are Christian. And Donna starts off by saying that we felt you had reasonable thoughts as to what the judge might do or say regarding this, quote, charade we had hoped you'd participate in. But then Donna goes on to, she basically seems to want to revert back to this ploy because she says, but then I thought about it. Well, who would have thought that this judge, when we're paying $600 an hour for 10 months, who would have thought that this judge would have denied the motion to relocate? And she even says, well, she's a graduate at FSU Law School, so she probably sees nothing wrong with living in Tallahassee. And then she goes on to say, look, this won't even be maybe a bad thing with this judge because, she's a Christian Black lady. And I looked up her campaign donations, and she had a lot of donations from church pastors and ministers. So she's probably it's going to be music to her ears to hear that the children have found Jesus. The other interesting thing here is clearly they've all been talking about it because she mentions here, Wendy, most of the wars that have been fought for the last couple hundreds of years have been over religion. Charlie brought up a good point when he said that Americans were dropped behind enemy lines during World War II wearing the other side, evil groups' uniforms to get what they wanted. And then she says, hey, maybe you could dress your kids up like these horrible group uniforms. Oh my gosh. And then she says, and hey, look, just because they're baptized doesn't really make them Christian. The other thing that I thought was interesting from this email was that, again, she's going into this, I think, apparent disdain for Dan wanting to raise the children in, a religious way. Because she says here, the extremism that Gibbers is already teaching the boys is nothing more than brainwashing. Religion is brainwashing. It's control of the masses. It affects who your friends are, what activities you do, how you eat, how you dress, how you pray, everything. There is no doubt that you will have two little Orthodox young men on your hands with the only religious influence over them being Gibbers. He's already got them thinking that people who eat shrimp are bad. Uh-oh. Hot dogs are disgusting. Lobster is gross. Oh my God, there we go. That's it. You cannot tell the Adelson family that lobsters are gross. I also thought it was interesting in here. She says that, she's telling Wendy it's all about negotiating. And then it looks like she said that they had actually consulted with two attorneys who are both excellent negotiators, one of whom we will most likely hire for the financial offer. This is, again, a financial offer to Dan to try to get him to agree to let Wendy move to South Florida with the kids. And then she goes on to say down here, I'm not saying we're not going to continue with hiring an attorney to negotiate and make a financial offer. I don't think you realize the type of offer we're considering. We're planning on you, Charlie, and Dad and I going as high as equal parts in a $1 million offer. That's $333,000 from each of us. And what I thought was interesting there is, if I recall during Wendy's testimony at trial, she made it seem like the three people were Mom, Dad, and Charlie. I don't recall her testimony having her be one of those three. Towards the end of the email, she says, everything has a price. Now is the time to start. You said that this divorce is not about winning and losing, that it's not a competition. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family teaching in Tallahassee. And there, guys, I think is where it all begins. So the divorce was finalized on July 31st, 2013. A day after the parties had signed their marital settlement agreement. However, peace did not last long. And in October of 2013, Wendy filed a motion to enforce the marital settlement agreement, arguing that Dan had failed to pay the full amount of $120,000 equity transfer that he was supposed to make, and that he also failed to pay $10,000 to her attorney. They did acknowledge that he had transferred $50,000 of the $120,000. So Dan responded to these allegations on January 30th, 2014 with 3 pleadings. First, he responded to her motion and basically argued that, first of all, he had transferred $54,725 in equity. But more importantly, he argued that it was because of Wendy's first breach of the marital settlement agreement terms that basically gave him the right to withhold future payments of that $120,000 until Wendy's breaches were cured. So the other 2 pleadings were a discovery request where he was basically asking for information regarding her Charles Schwab account. Third pleading was a motion to shorten the time for Wendy to be required to respond to his discovery request because there was an upcoming hearing in a couple of weeks on Wendy's original motion to enforce the settlement agreement. Dan had also noticed Wendy up for deposition, and this clearly did not sit well with Wendy because on February 4th, 2014, she filed a motion for a protective order, basically asking the court that she not be allowed to depose her. Now, does that sound like 2 parties that are getting along together post-divorce? So let's go to the next pleading where I believe shows motive. Okay, so on February 14th, 2014, Dan filed 2 pleadings. First, he filed an objection to Wendy's motion for a protective order to not have to appear for a deposition. But perhaps more importantly, he also filed his own counter motion to enforce the terms of the marital settlement agreement. And specifically, this is one of 2 counter motions that Dan filed to enforce the MSA. Now, it's important to note that both of these motions were yet undecided at the time of his murder. And you also recall that Wendy alleged that her and her attorney did not take these counter motions seriously. So let's take a look for ourselves. So again, we're going to start with the first counter motion, and that's the one here that was filed on February 14. And this one relates to financial issues. So with respect to the financial allegations, as we went over earlier, he alleges that financial affidavit from January of 2013, he alleges that there was false and misleading information in that affidavit. And then here we went over this. These are the different things that he said were false or misleading. What happens next after that pleading is we get another email from our favorite grandmother. Honey, Okay, your attorney must depo Elvis to see if any of the retirement accounts that Elvis has ever had a check written from them during the course of your marriage, if any of them were funded through any joint assets, your mutual Schwab account, or in any way passed through joint financial accounts, then you are entitled to a portion of those accounts. First takeaway, I guess they've changed Dan's nickname from Jibbers to Elvis now. Okay. Even if nothing was ever done improperly on those accounts, and he has some very large retirement accounts, let's aggravate him the way he's trying to aggravate you and make him do the research and show statements from every month, from the date of your marriage to the date of the filing of the divorce. You need to see where whatever he's deposited into those accounts where the money came from. It's very possible some of it came from your joint Schwab account, and then he's up you know what's creek. Why shouldn't he have to do this? It's what I mentioned to Kristen in court yesterday, and she nodded her head. Now she needs to do something about it. Second takeaway, Donna's now going to court. Oh my gosh. Okay. Also, what can your attorney do to be proactive to give him some grief? It seems like you're always on the defensive, but I don't see her doing anything offensive. I was really surprised that you didn't speak with her prior to meeting her in court. Can't you meet with her and work out a plan of attack or some sort of strategizing so you know what you're up against and what else he can do? When is there an end to this nonsensical litigation and waste of the court's time and your financial obligation to your attorney? That Donna and Harvey were paying for her attorney, allegedly. I think it's really important to get the parenting coordinator to either testify or be brought to deposition, perhaps by your attorney, so we can get her to request that Elvis be court-ordered for psychological testing. And if he's this off, perhaps he should not be permitted to take the children out of the country. What happened with the dean? Any help, or do you need to proceed to the provost? Something has to be done with this you-know-what. So what's she doing with the law school? Allegedly. Call us if you feel up to it tonight. If you're too tired, then call us in the morning after you leave the boys at school if you can. Love, Mom and Dad. And as Charlie says, we're one and the same. After this February 18th email, Wendy does, I guess, get with her lawyer, and they file on March 10th, 2014, a motion to dismiss Dan's counter motion to enforce the marital settlement agreement. Basically says Dan's he's unhappy with the MSA. All he does is allege pre-divorce behavior. And it's basically arguing that they call him a disgruntled former husband who can't move on. So I guess that's what Wendy meant when they didn't take it seriously. But anyway, that's what their response is. Now, the next pleading, in my opinion, is the biggie, which is Dan's March 26th second counter motion to enforce the marital settlement agreement. And this was on parenting issues. So the first argument Dan makes is that Wendy regularly refuses to make all reasonable efforts to facilitate communication with Dan and the children. And so he first speaks to the video conferencing, and this is the Skype. What's interesting is this argument that she has that it's, not in the best interest of the children isn't even credible because she herself regularly facilitates contact with the children when Dan has children. So Dan is very open policy of facilitating Skype or FaceTime whenever he has the kids, but she won't do it when she has the kids. She won't do it for him. So Dan alleges next that Wendy regularly fails to facilitate telephone contact with his children. Under the agreement, whenever the parent has the children in custody, they have to make sure that between 6 and 7 p.m., the kids have a few minutes to talk to the other parent. And he says that basically she consistently fails to do this. She also thwarts his efforts to have that communication by making sure they're in a distracted or noisy environment. She fails to return drop calls. She regularly allows calls to go to voicemail. And even one time when he texted her he was going to be a few minutes late after 7, she just basically ignored it. The third argument, and this one's important because it's now starting to involve Donna directly, is that the former wife routinely violates the settlement agreement's right of first refusal. So basically, whenever the person that has custody at that time, the time sharing, if they need to do something that would mean that they have to have a third party watch the children, the other former spouse has the right of first refusal to watch the kids. What he says is she regularly just violates that right he has of first refusal, and she does it with no apology. And so he says that the violations are troubling because the former wife's mother, who is frequently asked to watch the children, is a source of parental alienation efforts, as outlined in a few minutes, and the frequent outsourcing of care to the maternal grandmother leads to the former wife ignoring the preschool director's recommendations that the children be sent to preschool regularly so that they can enhance their social development skills. Apparently, Dan's arguing that she has this regular habit of pulling the kids out of school. He also alleges that she violates her duty in form. So like whenever she takes the kids out of town, she's supposed to let the other spouse, she's supposed to let him know where they are. And apparently one time she said she was going to her parents' home. And in fact, she went to Orlando. He says he also alleges that she fails to follow clinical recommendations of child development experts. This next argument is troubling because of the timing. So basically, again, this motion was filed on March 26, 2014. And what he alleges here is that Wendy violates the MSA by refusing to communicate and consult with him regarding education and other matters. So apparently, after a program in January of 2014 at Creative Preschool, Danny asked Wendy would at any time convenient be willing to discuss their oldest child's future schooling in his transition to kindergarten. She flatly told him no. Only a month later, after she was made aware of the former husband's intent to file an enforcement motion related to parenting issues, did Wendy exhibit some willingness to communicate with Mr. Markel, but she still refuses to converse with him directly. As a result, the opportunity to discuss various new potentially acceptable schooling options has passed. The school situation for next year remains unresolved, although the recommendation of the preschool director has been to minimize disruption to the children's life and to continue them in the programs with friends and teachers that each has had for the last 3 years. Mr. Markel agrees with this assessment, which seems especially appropriate since Ms. Adelson has indicated an intent to change homes for the second time in 2 years. What's that saying is a couple things. First of all, it's sounding like Wendy wasn't going to work with Dan on the education front until Dan had to probably threaten that he was going to file an enforcement motion, which is what this is, this March 26th filed. Because remember, in February, his motion to enforce the settlement agreement was on financial issues. The other thing that's interesting about this is, okay, well, of course, this pleading was March 26th. Dan's saying here that, look, March 1 was the deadline. As of right now, we're just going to basically have to keep the kids in the same school they're in. That's very interesting, guys, because what was going on the week of his murder, and who was he talking to literally when he was being murdered, when he was being shot?
How are you employed?
I am a music teacher.
All right. How were you employed back on July 18th of 2014?
I just quit my job at the School of Arts and Sciences in Tallahassee to accept the job that I currently teach at.
All right. And do you recall a phone call with Dan Markel that occurred on that date, July 18th, 2014, around 11 a.m.?
Yes.
Did something unusual happen while you were on that call with Mr. Markel?
Yes.
Could you explain what that was?
He said, "Can you please hold on a second? There's an unfamiliar person in my driveway." I said, "Yeah, sure." And then I waited for him to get back to me. He never did. I heard a loud sound, and then I heard him breathing like this. He never spoke another word to me. I asked him, "Are you okay?" I screamed into the phone, "Are you okay?" And then I hung up and texted him, "Are you okay? Is everything okay?" And then I called 911.
Right. And was the nature of your call with Mr. Markel having to do with your position as a music teacher?
Yes, he was interested in my opinion of the School of Arts and Sciences.
I see. All right. And so he asked you just to hold on because there was someone in his driveway.
Yes.
All right. Go ahead.
I said, he told me he was driving home, and then it sounds like he got there and saw an unfamiliar person.
All
Yes.
right. And was that the word that Mr. Markel used, unfamiliar person?
Yes.
No further questions.
And remember, the allegation was that Wendy unilaterally signed the oldest child up for a different new school, didn't tell Dan about it. He finds out about it that Wednesday before Friday, the day he was murdered. He finds out about it on Wednesday. And if you recall, he was wanting to talk to Wendy about it, but of course she let it go to voicemail that morning of his murder. And when he was shot, he was talking to a teacher of this new school and finding out information about the new school. Chilling. Dan also brings up that Wendy apparently enrolled the children into soccer without consulting him. And Dan says, although he was enthused that they want to be involved in soccer, the point is she keeps making these unilateral decisions that violate the separation agreement. And that's why he says, since the separation and the divorce, she's consistently been unwilling to communicate directly or with a therapist about significant matters affecting the children. And he believes, in light of her refusal to communicate about important parenting issues, then he should be, that it's the best interest of the children that he be given provisional, full decision-making authority on these issues. And he said, look, he'll consult with Wendy, and it'll be provisional, and it can go away when she demonstrate that she's able to reasonably communicate with him about the best interests of their children. Sounds reasonable to me. Here's the portion of the motion where Donna is really directly involved. And so here we go. By flouting the right of first refusal, Wendy creates conditions for Dan to be disparaged in the presence of the children by their maternal grandmother. And Dan basically cites that on 3 separate occasions in November 2013, the children informed Mr. Markel, Abba, Grandma says you're stupid. When queried as to why Grandma, maternal grandmother Donna, would say such things, the children replied jointly, that is because she says you're trying to take her sunshines away from her. In December 2013, the younger son further stated to Mr. Markel in front of the former wife, Abba, Grandma says she hates you. The children were visiting with their grandparents at that time. That the children have heard disparaging statements from their maternal grandmother about their father is especially concerning in light of the fact that, as mentioned above, the former wife leaves the children unsupervised with her parents in violation of the court order right of first refusal. Mr. Markel is concerned that continued exposure to such negativity forms the foundation for parental alienation. Mr. Markel is puzzled by the maternal grandmother's behavior, as he has been supportive of the children's relationship with the maternal grandparents. Regardless of the rationale, the maternal grandmother's dislike of Mr. Markel must not be displayed in the presence of the children. The former wife is obliged to prevent disparagement of the children's father. The fact that the reports arose after the children spent substantial time with the maternal grandparents, either alone or with the former wife, is circumstantial evidence that the former wife has breached her contractual obligations in this regard. And that, guys, I think is something that the Adelsons took seriously. I'd say in particular, Donna. Just my opinion, allegedly. The last argument involves potential alleged gatekeeping that Wendy regularly deprives the children of access to Markel. And he gives a couple examples. One that I thought was weird is apparently, and this was, he cites an example on March 18, 2014. So just within days before the filing of this motion. Apparently, Wendy sought to prevent Mr. Markel from being at the preschool to visit the kids at the same time when she was planning to pick them up. The MSA clearly allows both parents to visit the preschool, but former wife instructed Mr. Markel that because she was en route to school now, that Mr. Markel should exit appropriately when I arrive. This imperious request was bizarre, inappropriate under the requirements of the MSA, and at odds with the reality of Ms. Adelson's past visits at the preschool during times when Mr. Markel picked the children up for his overnights. He ends the gatekeeping argument with basically saying this point about taking the kids out of preschool, taking them out of daycare. She basically creates what he says is 4 and 5 day stretches when the children are deprived of unhampered contact with their father. And that's because Wendy refuses to let Dan see the kids when it's, quote, her time. And as far as relief sought, again, I think this was the straw that broke the camel's back. As part of this relief here, he wants to enjoin the former wife from allowing the maternal grandmother, Donna, to have unsupervised time with the children, consistent with the right of first refusal, and to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father. The other thing that I think was important in this motion that I'm certain that I would take seriously is that he's asked that the court allocate to him provisional decision-making authority over these upbringing matters, subject to consultation with her and a family or child therapist, until Wendy no longer evidences an inability to communicate. So the last pleading that I think establishes that motive or that connection between Charlie Adelson or the Adelsons more generally is actually this last pleading that was filed by Dan's side before his murder. It's his memorandum of authorities in support of his 2 counter motions to enforce the marital settlement agreement. And again, there was the financial aspect of it, and then there was the kind of parenting aspect of it. Now, with respect to the financials, he was seeking relief from both Wendy and her attorney. And I think that this portion here was quite interesting. He basically said that this court must keep in mind that the former wife is not only an attorney herself, but a clinical law professor. It also, her being a lawyer, she's subject to the rules of professional conduct for attorneys. And that basically what he says is that his wife, through her counsel, took a simple divorce and made it complicated, nefarious, and expensive. Now, with respect to the other aspect of his counter motions, which was about parenting and upbringing and custody generally, I thought this was super interesting. Basically, he's talking about their education and that he talks here about a recent parental conference that he and Wendy had with the head of their current school. And apparently what was said was that by the educator was that the children would substantially benefit from continued immersion in the preschool. They've spent virtually their entire childhood, and that in the elder son's case, he would indisputably benefit from an extra year of kindergarten due to his late birthday and the concomitant status of his social and emotional development. She also made clear that it was harmful for the elder child to be pulled out of school as frequently as Wendy was doing because it was causing the child to effectively lose an extra day in his transitions back to group play. Despite various attempts to speak to and consult with Ms. Adelson about the children's continuing education, She has refused to communicate with Mr. Markel her preferences, let alone her reasons, requiring him to ask for the allocation of decision-making authority over matters related to the children, contingent on his consulting family therapist and Ms. Adelson. So that's really sad, right? Because as we know, like I said, the day of his murder, when he was shot, he was talking to a teacher from a school that Wendy had allegedly signed the older son up for that was going to happen in a matter of weeks when the school year would start, presumably in August, that she did on her own accord without even talking to him. And it's crazy that that is like literally what Dan is talking about in this last pleading that he filed in the case on May 5th, 2014. In my opinion, this does not paint a picture of two former spouses reasonably getting along and having a healthy co-parenting relationship. We don't have Wendy's side of these motions. In particular, the motion that Dan filed in March about all of these parenting issues that we just went through. We don't have a pleading with her response to any of that. And presumably, according to Wendy, she didn't take any of these motions very seriously. They were pending, though, on the date of his death. So this is the last pleading that either party made in this case. And it was made by Dan's new lawyer. And you'll see here it's a suggestion of death. And it gives the date that Dan ultimately succumbed to his injuries. So there you go. Those are the pleadings from the public record that, in my opinion, would be helpful for the state to use to establish that motive, whether it be specifically regarding Charlie Adelson or the Adelson family as a whole. I have to admit that when I read through the file, it was really sad, and just another example of why none of this was necessary. So thanks again, guys, for joining. I hope to see you in my next one. I'm working on another Markel trial countdown, which should be up shortly. And thanks again for joining. I hope to see you in my next one.